name is a.shautsova. I'm an immigration attorney from New York. In today's video, we will be discussing adjustment of status. Adjustment of status is a term of art used by immigration attorneys to describe the process of receiving permanent residency in the United States. Why some people can adjust status and some cannot? What is required to adjust status and receive green card in the United States without leaving the United States? And what obstacles you may face when you are trying to adjust status. Thank you very much for joining. If this is your first time here, welcome. I'm a practicing attorney with more than 15 years of experience. I help clients in New York and all other states of the United States and overseas. And on my YouTube channel, I regularly post interesting videos and news updates about the United States immigration practice. So welcome, please sign up for my channel and let's start. A typical question I would receive on a daily basis would be, can my mom or my sister sponsor me in the United States? I've been living here all my life. My mom just became a citizen, or my sister or my brother, I have a sibling who are US citizens. Can they help me? Or if an employer can help me, I've been living here for 30 years, can an employer help me to get immigration status? So let's see how it works. Why some people can receive status and some cannot. For adjustment of status, we need a green card application, form I-485. We also need a basis for adjustment. And this basis can be usually approved I-130 petition, approved I-140 petition, I-360 petition, VAWA case or special immigrant visa or special immigrant juvenile case approved, or maybe you received asylum or refugee status. Those are typical grounds for adjustment of status in the United States. So you need an application for adjustment of status and you need basis. These two, if they connect together, you can have your green card in the United States. But here is a trick. Very often they do not connect. You see this red line? They cannot connect because of this red line. So what would prevent the application and the basis to connect? Inadmissibility bars. Inadmissibility bars can be different for different types of basis related to adjustment of status. For example, depending on who filed this I-130 for you, we can find different inadmissibility bars or we will not have them. If I-130 was filed by a US citizen spouse, inadmissibility bars such as unlawful presence in the United States or unlawful employment will not apply. And as long as you can show that you have legal entry, which is almost always required for adjustment of status, and you have a provable or approved I-130 petition, this and this will unite and you will get your green card in the United States. But if the same I-130 form was filed by your sibling, you will also have to show, in addition to legal entry, that you spent your time in the United States in legal status. You spend your time in legal status. Otherwise, you will have a problem of inadmissibility under the law. Those who are trying to adjust status in the United States in the family preference category. Family preference category is everyone who is not an immediate relative. Immediate relative are only a spouse or a parent of a US citizen or a child under 21. Those who are in the preference category must show they maintained lawful non-immigrant status in the United States throughout their stay in the United States. Otherwise, they're inadmissible. So we check who filed the I-130, and if you will have to worry about this red line, inadmissibility. Same applies for other grounds of adjustment of status, I-140, I-360. For example, for I-360 VAWA case, we need to have I-45. Now, inadmissibility related to entry does not play a role. If you are a VAWA beneficiary, you can show that you entered the United States, however, with inspection or without inspection. It does not matter if you maintain your lawful status here or not. These two will unite for I-360 ground of your green card. So that's what it takes to determine whether your green card application and your basis for the green card application are going to work for you to receive your green card in the United States. Now let's talk about typical cases and see when somebody can adjust status in the United States. So let's say you are thinking about family-based immigration. I-130 form is going to be involved. But we also need to see who may file that form for you. If it's someone who is your US citizen spouse or child who reached 21 years old, then all you need to show is that you have a legal entry. When you came to the United States, you came on a visa or parole, and that you do not have misrepresentation or fraud or criminal convictions, usually, right? The fact that you could have overstayed your visa in the United States would not matter. That's for I-130 filed by a US citizen spouse. That's why most people who overstay their visas are boxed into this situation where they can fix their status in the United States only if they marry a US citizen. If the same I-130 form is filed by your parent and now you are an adult over 21, in addition to having to show that you entered legally, don't have criminal convictions, misrepresentation, or fraud, you also have to show that you maintained your lawful non-immigrant status throughout the entire stay in the United States. The same is true if the basis for your green card is I-140 form, but certain exceptions may apply. Again, the lawyer's job is to find out which exceptions may apply to your case, or if there are no exceptions, waivers. For some grounds of inadmissibility, there are waivers. Exceptions, I would call 245I a rule as an exception, grandfathering rule. So I just gave you this whole lecture that usually you have to show you are in lawful non-immigrant status throughout your stay in the United States. But if you can show that you resided in the United States in December of 2000 and someone filed for you petition before April 30th, 2001, you may qualify for 245I exception to the general rule of not being able to adjust once you lost your status in the United States or entered the United States without inspection. Or, for example, some people who filed for asylum in the United States while they were still in status sometimes may successfully argue that they are allowed to adjust status based on I-140 employment petition due to the fact that they could not maintain their lawful non-immigrant status due to no fault of their own, but because USCIS has not been calling them for the interview within 180 days, and it's supposed to have happened under the law. That would be an exception. It's hard to win this exception. I'm aware of only 2 cases, unpublished cases from a Board of Immigration Appeals where that exception worked. That's why usually I don't have clients who would like to try this exception. But I know many of you are asking, can I adjust status if I have asylum pending and I have a 40 opportunity to either to be filed for me, or I'm thinking about filing for it. So this is what it takes to get a successful adjustment of status in the United States. You have to check for your conditions, you have to make sure you're not inadmissible, and see if any exceptions or waivers may help you if you have any legal barriers. Thank you very much for watching. I hope this video is helpful. If so, please like and share it, and I hope to see you soon.